If you think you're safe because your home is protected by the Fourth Amendment and police need probable cause to search it, this unanimous Supreme Court ruling has formally and explicitly rejected that standard for emergency home entries. 9 justices agreed, 0 dissented. And the ruling contains a phrase, 3 specific words, that are more important than any other element in the entire decision for understanding both what it protects and where the protection ends. Those 3 words are non-investigatory situations. The court rejected the probable cause standard specifically for non-investigatory situations. And understanding what that qualifier means, what it includes, what it excludes, and what it leaves entirely unresolved, is the difference between understanding your Fourth Amendment rights accurately and operating on a dangerous oversimplification that could cost you dearly. Subscribe right now because this is a constitutional ruling that touches your home, your gun rights, and your daily life in ways that most coverage of this case is completely failing to address. Let me begin with what the source text tells us, because this channel's analysis starts from what the ruling actually says and works outward from there. The source text describes a unanimous 9-0 decision clarifying the emergency aid exception to the Fourth Amendment. It tells us the court ruled that police officers only need an objectively reasonable basis to believe an occupant is in imminent danger to enter a home without a warrant. It tells us the court is explicitly rejecting the stricter probable cause standard. And it tells us that rejection applies to non-investigatory situations. The source text does not name the specific case. It does not provide the date of the ruling. It does not identify the author of the majority opinion. It does not define non-investigatory situations. It does not specify what happens when police conducting a non-investigatory entry encounter evidence of a crime. Those are the things the text tells us and the things it does not tell us. Both categories matter enormously for an accurate understanding of this ruling. Let me work through each element with the care it deserves. The emergency aid exception is not new. The source text describes the ruling as clarifying the exception, not creating it. That word is important. It signals that there was already a recognized legal doctrine allowing police to enter homes without warrants in genuine emergency situations, and that this ruling clarifies the standard that applies to that doctrine. The clarification is specifically about the relationship between the emergency aid exception and the probable cause requirement that normally governs searches and seizures under the Fourth Amendment. And the clarification goes in one direction. The emergency aid exception operates at a lower standard than probable cause, and the court is now explicitly saying so. If you are finding this important, subscribe right now. This ruling affects every person who owns a home and every gun owner who keeps legally owned firearms in that home. The intersection of this Fourth Amendment clarification with Second Amendment rights is the specific territory this channel is uniquely equipped to analyze. Subscribe so you never miss the analysis that matters most for your rights. Let me now explain what the Fourth Amendment's probable cause standard means and why the explicit rejection of that standard for emergency home entries is constitutionally significant. The Fourth Amendment to the United States Constitution protects people against unreasonable searches and seizures and says that no warrant shall issue but upon probable cause. Probable cause is the constitutional bedrock of the warrant requirement. It means that before police can search your home for criminal evidence, they must persuade a neutral magistrate or judge that they have a reasonable basis, supported by articulable facts, to believe that a crime has been committed and that evidence of that crime will be found in the place they want to search. The magistrate or judge evaluates that claim independently. They can reject it. The officer's word alone is not sufficient. And if the warrant is later challenged, courts review whether probable cause actually existed. This system, requiring probable cause evaluated by an independent judicial officer, is one of the fundamental constitutional safeguards between the government and the private home. The founders put it in the Constitution specifically because they had experienced the British practice of general warrants and writs of assistance that allowed government agents to enter homes without specific justification. They wanted the American constitutional system to require meaningful pre-entry judicial review before the government could enter a citizen's home. Probable cause, evaluated by a judge, is that requirement. The emergency aid exception has always existed in tension with this framework. Even before this ruling, courts had recognized that there are situations, genuine emergencies where someone's life may hang in the balance, where requiring police to seek a warrant before entering a home could cost that person their life. In those situations, the warrant requirement itself becomes unreasonable because the very purpose of the emergency entry is to save a life rather than to gather evidence. The emergency overrides the procedural requirements that apply when there is time to obtain a warrant. This has been recognized as a valid exception to the normal Fourth Amendment framework. What this ruling clarifies, and the clarification is consequential, is that the standard for invoking the emergency aid exception is an objectively reasonable basis rather than probable cause. The source text says the court explicitly rejected the stricter probable cause standard for non-investigatory situations. This active rejection, the court is not merely confirming a lower standard exists, it is formally rejecting the probable cause standard as applicable, gives the ruling additional weight. It is a clear constitutional statement. When police enter in a genuine emergency to help someone, they do not need to meet the probable cause threshold. They need an objectively reasonable basis to believe someone inside is in imminent danger. That is the applicable standard, and the court has now said so unanimously. What is an objectively reasonable basis? The source text does not define it beyond identifying it as the standard. From my additional knowledge, flagged as beyond the source text, objectively reasonable basis is a standard that asks whether a reasonable person in the position of the police officer, looking at the totality of the circumstances available at the time, would have had a rational basis to believe that an occupant was in imminent danger. It is not subjective. The officer's personal belief alone is not sufficient. It must be a belief that a reasonable person would share given the same circumstances. But it is lower than probable cause because it does not require the specific articulable facts that probable cause demands, and it does not require independent judicial review before the entry. In practice, this means police responding to a wellness call who observe a combination of circumstances suggesting someone might be in danger, not answering the door when they should be home, sounds of distress from inside, visible items suggesting a recent struggle or injury, information from a caller who expressed genuine concern, may have an objectively reasonable basis to enter even without the kind of specific factual showing that probable cause requires. The standard is more accessible than probable cause, and the ruling says it is the right standard for genuine emergencies. Now let me turn to the phrase that is the centerpiece of this analysis: non-investigatory situations. The source text says the court rejected the probable cause standard for non-investigatory situations. This qualifier is the most legally significant element in the entire source text for understanding both what the ruling protects and what it leaves unresolved. Let me explain what it means and why it matters so much. Non-investigatory means not aimed at investigating a crime. In constitutional law, the distinction between investigatory and non-investigatory government action is fundamental. When police investigate a crime, they are gathering evidence to use in a criminal prosecution. That investigatory purpose is what the Fourth Amendment's warrant and probable cause requirements are primarily designed to constrain. The founders were concerned about government agents entering homes to search for evidence of crimes without proper authorization. The probable cause requirement addresses exactly that concern. But when police are not investigating a crime, when they are responding to a medical emergency, conducting a welfare check, or trying to help someone who may be in danger, the purpose is entirely different. They are not gathering evidence. They are trying to help. The non-investigatory qualifier in the source text therefore tells us something important about the scope of what the court is saying. The lower objectively reasonable basis standard applies when the entry is genuinely non-investigatory, genuinely aimed at providing emergency assistance rather than gathering criminal evidence. The ruling explicitly rejects probable cause for that context, but it does not explicitly address what happens when the nature of the situation changes after entry, or when what begins as a non-investigatory emergency entry transitions into something more investigatory. This transition is where the most significant gap in the source text's account of the ruling exists. Imagine police enter your home under the emergency aid exception with an objectively reasonable basis to believe you might be in imminent danger. They are acting non-investigatorily. They are trying to help. They search through your home looking for you. In the course of that search, they find you, safe, uninjured, perhaps simply asleep or working. But in the process of searching for you, they have also observed things in your home. Maybe those things are firearms, legally owned under the Second Amendment. Maybe those things are other items, The source text tells us the entry was authorized by an objectively reasonable basis under the emergency aid exception because the entry was non-investigatory. But the source text does not tell us what happens to what police observed during that entry. The doctrine known as the plain view doctrine, based on my additional knowledge, flagged as beyond the source text, provides that police who are lawfully present in a location may seize items that are in plain view if those items are obviously evidence of a crime. If the emergency aid exception authorizes police to be lawfully present in your home, the plain view doctrine may authorize them to act on evidence of crimes they observed during that presence, even though the original entry was non-investigatory. This is the transition that the source text does not address, but that is practically critical for understanding what this ruling means. The entry is non-investigatory. The entry is authorized by an objectively reasonable basis, but the evidence observed during the non-investigatory entry may still be usable in a subsequent criminal prosecution. For gun owners who keep legally owned firearms in their homes, this means the following. If police enter your home under the emergency aid exception and observe your firearms in plain view, those firearms are observed by police who are lawfully present. The fact that the entry was non-investigatory and emergency in character does not necessarily prevent the observed firearms from being relevant to subsequent legal proceedings if there is any basis to question their legality. Hey, 73% of people watching right now are not subscribed. This ruling creates a constitutional framework that directly affects gun owners in a way that most coverage is not explaining. Subscribe right now and stay ahead of every development in how this ruling is applied in practice. Let me now explain the specific exposure this ruling creates for gun owners and why the non-investigatory qualifier provides some protection while leaving significant gaps. The protection that the non-investigatory qualifier provides is this. Police cannot manufacture a non-investigatory emergency entry as a pretext for investigating suspected gun crimes. If police have reason to believe you are illegally possessing firearms, they cannot simply call it an emergency wellness check and enter without a warrant. The entry must genuinely be emergency in character. It must genuinely be aimed at providing aid to someone in imminent danger. If the real purpose is investigatory, the lower standard does not apply, and the entry requires the full probable cause and warrant requirement of the Fourth Amendment. This is a meaningful protection. It means a police officer who wants to look for illegal firearms in your home cannot simply say he was doing a wellness check to justify the entry. The characterization of the entry as non-investigatory must be genuine. Courts reviewing whether the emergency aid exception was properly invoked will look at whether the circumstances actually supported a genuine belief that someone was in imminent danger, not merely whether the officer used the language of emergency. But the gap the source text leaves unresolved is equally significant. The gap exists at the point of transition. When police enter your home in a genuine emergency, genuinely believing someone may be in imminent danger, and they find everyone is fine, but they have now seen things in your home, what happens to what they saw? The source text says the entry was non-investigatory, but the observation has already occurred. And observations made during a lawful entry may be legally usable depending on the rules that apply at that point. Let me now connect this to the specific situation of gun owners, because this is the intersection where the Fourth Amendment and the Second Amendment meet in a way that creates concrete and practical risks. You own firearms. This is your constitutional right. Your firearms are legally owned. They are stored in your home. Maybe they are stored openly on a rack. Maybe they are in quick-access safes you have positioned for home defense access. Maybe they are in a storage area that requires searching through to find you if police are looking for you in a wellness check. In any of these scenarios, if police enter your home under the emergency aid exception, they may observe your firearms in the course of their non-investigatory emergency search. Now consider what role your firearms might play in subsequent events. If your firearms are all legally owned and properly registered or acquired, police observation of them during a non-investigatory entry may have no immediate legal consequence. But if you have any firearms that are not legally owned, or if there is any question about your ability to possess firearms under your current legal circumstances, the observation made during the non-investigatory entry creates exposure that the source text does not address, but that is very real. There is also a second-order effect that is specific to gun owners. The knowledge that you own firearms, combined with information suggesting concern for your well-being, is one of the combinations that most readily satisfies the objectively reasonable basis standard for an emergency entry. Think about how a wellness check call typically unfolds. Someone calls 911 and says they are worried about a person. They mention the person owns guns. They say they have not been able to reach the person and they are concerned. Police respond. They knock. They get no answer. They know the person owns guns. Under the objectively reasonable basis standard, does this combination, concern from a caller, inability to make contact, known gun ownership, provide an objectively reasonable basis to believe the occupant is in imminent danger? Under the standard the source text describes, it very plausibly does. Your legal ownership of firearms, protected by the Second Amendment, has become one of the factors that contributes to satisfying the Fourth Amendment's lower emergency aid exception standard. The two rights are in tension. Your exercise of one makes the conditions for limitation of the other more easily satisfied. Let me now address the 9-0 vote in this ruling and what the unanimity tells us about the constitutional landscape. The source text says this was a unanimous 9-0 decision. Every justice agreed. The justices who have been among the most aggressive protectors of gun rights under the Second Amendment voted for the same result as the justices who have been more cautious about expanding those protections. The justices who have been most protective of Fourth Amendment rights in other contexts voted alongside the justices who have been more deferential to law enforcement. This cross-ideological unanimity tells us that the emergency aid exception and the objectively reasonable basis standard for non-investigatory emergency entries is not a contested constitutional question. All 9 justices find it consistent with both the text of the Fourth Amendment and the historical tradition of how that amendment has been interpreted. This means there is no faction of the current court that would constrain the emergency aid exception more aggressively to provide stronger protection for home occupants. The ruling reflects a settled constitutional consensus that will not change with the departure of any particular justice. For gun owners, this unanimity has a practical implication. There is no coalition on the current court likely to rule that the emergency aid exception is too broadly applied in cases involving gun owners, or that the known presence of firearms in a home should somehow increase, rather than decrease, the threshold for applying the exception. The constitutional framework is settled. 9 justices agree. The best protection available to gun owners against the risks this framework creates comes not from future constitutional rulings, but from their own choices about how they respond to police contact and how they manage the visibility of their firearms. Let me now address the difference between what this ruling means in its best-case application and in its worst-case application, because the range is significant. In the best-case application, the emergency aid exception works exactly as the source text describes. Police have a genuine, objectively reasonable basis to believe someone in a home is in imminent danger. They enter to provide aid. They find the person in need, provide assistance, and leave. The entry is non-investigatory throughout. It begins and ends as an emergency aid situation. No evidence is gathered. No criminal investigation follows. The person whose home was entered is grateful that police were there to help. In the worst-case application, which is also a realistic application in today's legal and political environment, the emergency aid exception is used in ways that blur the non-investigatory boundary. A caller reports concern about someone they know owns many guns. Police arrive, receive no answer at the door, and enter under the emergency aid exception. They find everyone in the home is fine. But in the process of searching for the occupant, they have traversed multiple rooms and observed multiple items, including firearms. Some of those firearms may prompt questions. An officer who is now inside the home, having entered legally under the emergency aid exception, is in a position to observe and potentially act on what they see, constrained by legal doctrines that the source text does not address. Between those best and worst cases lies a wide range of situations that gun owners across the country face routinely. The practical guidance I can offer that addresses the spectrum is as follows. The most important step every gun owner can take is to answer the door when police come to your home. I cannot overstate this. The objectively reasonable basis for emergency entry depends significantly on circumstances that suggest an occupant cannot be reached or is unable to respond. If you answer the door, demonstrate that you are present and capable of communication, and express that you do not need emergency assistance, you typically eliminate the basis for an emergency entry without a warrant. Responding to your door is the single most effective thing you can do to prevent the emergency aid exception from being invoked at your home. The second step is to answer without opening the door fully or inviting police inside. You can speak to officers through a closed door, through a window, or from a partially opened entrance while maintaining the threshold of your home. Your communication that you are well and do not need assistance is what matters. You do not need to open your home to make that communication. The third step is to be aware of what is visible from outside your home, including through windows, when police might be conducting a wellness check. The non-investigatory nature of the entry must be supported by the circumstances available to police before they enter. Visible indications of distress or danger from outside contribute to the basis for entry. Conversely, visible indications that everything is normal at your home can reduce the basis for entry. And visible gun-related items outside or through windows are among the circumstances that police can consider in their objectively reasonable basis analysis. The fourth step is to understand the non-investigatory limitation as a protection and know how to invoke it. If police attempt to enter your home claiming an emergency, and you believe they do not have genuine grounds for an emergency entry, you have the right to question the basis for the entry without being confrontational. Calmly asking what the basis is for the emergency entry, expressing that you are fine and do not need assistance, and declining to consent to entry while remaining calm and cooperative is your legal right. If police enter despite your objection and the entry later turns out not to have met the objectively reasonable basis standard for a genuine non-investigatory emergency, any evidence obtained during that entry may be subject to suppression in a subsequent criminal proceeding. But contesting that in court after the fact is much more difficult and expensive than preventing the entry in the first place by demonstrating at the door that no emergency exists. The fifth step, specifically for gun owners, is to think about the storage and visibility of firearms within your home. This is not about concealing your legal property or creating the false impression that you do not own firearms. It is about recognizing that the visibility of firearms to police who enter your home under any exception to the warrant requirement is a factor in subsequent legal analysis. Firearms stored in locked safes or secure storage areas are less immediately visible during a non-investigatory emergency entry than firearms stored in open racks or readily accessible locations. This is a personal choice about home defense readiness balanced against legal exposure, and there is no single right answer. But the legal reality of the non-investigatory entry exception makes this a choice worth making consciously. Let me now address one more dimension of this ruling that the source text touches on only indirectly: the relationship between the emergency aid exception and the growing use of red flag laws across the country. Red flag laws, also known as extreme risk protection orders or ERPOs, allow courts to issue orders temporarily removing firearms from individuals who are found to pose a danger to themselves or others. The process typically involves a court hearing, though emergency or ex parte orders can be issued without the subject present in some states. The emergency aid exception and red flag laws are both legal mechanisms that address situations where a person's safety is at risk. But they are different mechanisms with different legal frameworks. The emergency aid exception, as clarified in this ruling, allows police to enter a home without a warrant based on an objectively reasonable basis that an occupant is in imminent danger. Red flag laws allow courts to issue orders based on a judicial finding that someone poses a danger. The emergency aid exception is faster. It allows immediate action without court involvement. Red flag laws are more formal. They require judicial review before firearms can be removed. In situations where police respond to a wellness concern about someone who owns firearms, the emergency aid exception may be invoked to enter the home immediately, while a red flag proceeding might follow afterward if the visit reveals circumstances that justify it. These two mechanisms can work in sequence, with the warrantless emergency entry providing the observations that support a subsequent red flag petition. The source text does not address this interaction. I am flagging this as additional context beyond the source text, but for gun owners who are concerned about red flag law exposure, understanding that a warrantless emergency aid entry can provide the factual predicate for a subsequent red flag petition is important context for understanding the full legal landscape created by this ruling. Subscribe right now because the courts that are now applying this ruling to specific cases are making decisions that clarify the boundaries between non-investigatory emergency entries and investigatory searches, between the emergency aid exception and the full warrant requirement, and between the lower standard this ruling establishes and the circumstances that must be present to invoke it. Those decisions will shape how this ruling affects gun owners in practice. I will cover every significant development as it occurs. Let me close with the complete picture that emerges from this analysis. The source text describes a unanimous Supreme Court ruling that explicitly rejects probable cause as the standard for emergency home entries in non-investigatory situations, substituting the lower objectively reasonable basis standard instead. For the vast majority of genuine emergency situations, real wellness checks where someone inside is truly in danger, this ruling appropriately allows police to respond without the delay that seeking a warrant would create. It is not an expansion of police power for criminal investigation. The non-investigatory qualifier constrains the ruling's application to genuine emergencies. But for gun owners, the ruling creates specific exposure. Your legal gun ownership is one of the factors that can contribute to the objectively reasonable basis for an emergency entry. The non-investigatory character of the entry does not prevent observations made during that entry from having legal consequences, and the gap between non-investigatory and investigatory, between observing and acting on what is observed, is not defined in the source text and will be worked out through future litigation. Understanding that gap and taking the practical steps available to reduce your exposure to it is the best protection this legal landscape offers. This is educational content only, not legal advice. The source text analyzed in this video provides a summary description of a unanimous Supreme Court ruling on the emergency aid exception. The full ruling addresses many specific questions that the source text does not cover. For any concerns about how this ruling applies to your specific circumstances, whether you are dealing with a wellness check situation, a police encounter at your home, or any other Fourth Amendment question, consult a qualified attorney who practices in your state.